Welcome to the meeting of Sebastopol Planning Commission of October 8th, 2024. We will start with a roll call, please.
Commissioner Ottinger?
Here.
Commissioner Burns? Sorry. Here. Chair Fritz?
Here.
Vice Chair Hanley?
Here.
And Commissioner Fernandez?
Here.
And 5 out of 5 members are here, and we do have a quorum.
Thank you. Next item is an opportunity for members of the public to speak on an item that is not on our agenda tonight. So if you have something you'd like to address the Planning Commission about that is not on our agenda, now is your opportunity. Anyone in the room? Seeing no one in the room, we will go to Zoom. And go ahead, Linda, you can unmute yourself and make your comment.
Okay, you can hear me, right?
Yes, we can.
Me? Can you hear me?
Yes, we can.
All right. Okay. So anyway, first of all, I want to thank Everett for attending the recent City Council meeting. The rest of you ought to need to do the same. You know, it's my opinion that there's a serious disconnect from what's going on in this town with a lot of you. It does not appear that you are privy to what's going on in the ground here, and particularly the homeless thing. It turns out that Sebastopol is a magnet for the unhoused because we've got a reputation for being warm and fuzzy, and humane police. We've got really good cops here, and we've got a bunch of generous do-gooders here. Which I'm sorry to say, the experiment here, the pilot program with RV Village, which is almost next door to me, backfired seriously, and we need to stop enabling bad behavior, which continues to go on. So I am suggesting strongly that you all need to take a look at the consequences of your policies and at least come and walk up to the Redwood Village and look at the 5 vacant commercial properties there, and then you walk the sidewalk there where the RV villagers, all the people that are in the RVs, and talk to them. They use that sidewalk as their
30
front
seconds.
yard. Find out what their stories are or what they want, and come up with some ideas on how to fix it. Also, your policies, you need to recognize that we lack infrastructure and the traffic problems for continued building. In my opinion, you need to slam the brakes on all of this building. We do not have the infrastructure for it, and the traffic is on Healdsburg Avenue now is spoken about the gridlock almost daily on KSRO. I just listened
2 minutes
to it.
are up. Thanks, Linda.
What?
That was your 2 minutes. Thank you, Linda.
Next time
No dramatic sound this time, huh? All right, not seeing any other members of the public wishing to make public comment. We will move on to our next item, which is a statement of conflicts of interest. Anyone have a conflict of interest for items tonight? Okay, no one has a conflict of interest. Next item is approval of minutes of September 24th. Are there any comments or corrections? Go ahead.
I move we approve them, but I do see one question about item number 8. I think the date is wrong on our next meeting, because our next meeting is today, not the 22nd. So except for that change, I approve the minutes of September 19th, 2024.
All right, any other comments? I actually have one addition as well. I believe Jane was at that meeting as a staff member. Were you not at our last meeting? All right, we'd add Jane to our staff list there. So we have a motion, if you're okay with that also.
Yes.
Kathy, do we have a second?
I'll second.
Thank you. We have a vote, please.
Commissioner Ottinger?
Yes.
Commissioner Burns? Yes. Chair Fritz?
Yes.
Vice Chair Hanley?
Yes.
And Commissioner Fernandez?
Aye.
And that is 5 out of 5. Motion passes.
Great, thank you. So our first public hearing, item 6A, is for 7605 Bodega Avenue, a use permit for an ADU to be used as a vacation rental. Can we have a staff report, please? Our staff members momentarily out of the room, so we'll wait for him to get back. All right, John, you're up.
Thank you. So this is a conditional use permit for a hosted vacation rental of an accessory dwelling unit for more than 31 days at 7605 Bodega Avenue, as noted above. This use permit to allow a hosted vacation rental of an ADU for more than 31 days is required by Table 17.260-1 of the Sebastopol Municipal Code. The applicant lives in the main house on the lot full-time, and the ADU is occupied by their parents about half of the year. The request is to use the ADU for a hosted rental when their parents are not in town to provide a passive income. As the ADU was built after 2017, the Sebastopol Municipal Code requires the approval of a conditional use permit by the Planning Commission. The applicant states that currently the ADU is occupied about, again, half the year by their parents, who typically split time between Sebastopol and Florida. The Planning Commission has recently talked about looking at both hosted and non-hosted vacation rentals, as well as rentals that include ADUs, and staff is continuing to work on those updates to the vacation rental ordinance. But until that time, city has no mechanism to put a cap on these types of rentals. The ADU, or the applicant, also states as part of their application that the intent of the ADU is to provide an aging in place space for their parents when they get to a point of moving here full time. I do want to note that I was made aware of a portion of the vacation rental ordinance that says each conditional use permit issued pursuant to this section shall be subject to an annual permit review and extension. No later than 1 year after the effective date of the permit, the owner or authorized agent shall submit that to the planning director for annual review established by the city council resolution. Along with the permit review form established by the planning director, the owner shall document compliance with all requirements of this section and shall also document each date on which the vacation rental was rented during the previous term of the permit. That did not make it into the conditions of approval tonight, but I would recommend that the Planning Commission add that as a condition of approval. And then I believe there was one other one that you had mentioned about total number of days throughout the year.
Yeah, so it's essentially an annual permit. It's a 1-year permit instead of having the term that we would normally use. I was not aware of this until today, so apologies for this not being clear in your staff report. I do think in this case, the applicant is requesting part-time use of the vacation, of the ADU in a vacation rental fashion. We have discussed the difference between a long-term rental, a long-term monthly rental, and vacation rentals, and being, taking the unit out of the housing stock. And the Planning Commission expressed a willingness to consider these one-off kind of situations, and you wanted the flexibility to be able to do that. And of course, the very next meeting, we bring you one of them before we've changed the code to do anything. But because the applicant is requesting that you only have part-time use, I think you can limit the number of days. And this reporting requirement matches the reporting requirements that's on the county's TOT form. So they have to report days that it was for rent on those quarterly reports for TOT as well. So I don't think it's an onerous requirement for reporting, but you'll need to talk about what you're comfortable with limiting as far as the number of days.
Thank you. Are there any questions? Go ahead, Kathy.
So maybe I misheard. Were you saying that he's asking for a hosted permit? Because this seems like it's non-hosted. There's no one living in that facility. other than the guests, as far as I understand.
Correct. The hosted component is the homeowner lives on site in the main residence, and the ADU would be the rental. So they're still the homeowner is still on site.
And this facility look kind of large with the 2 bedrooms. Is it still within the parameters of what an
Correct.
ADU is and not considered a second dwelling unit
Correct.
on the lot? Okay,
Correct.
thank you.
So right now, your code defines a hosted rental as the owner living on the property rather than in the home that's being rented. So that's what your code says right now. We talked at our last meeting about changing that to be the actual home so that we could say no more of these in ADUs. But again, you did express a willingness to look at these kind of one-off situations where it would not otherwise be available for long-term rent because they have their parents there now. So I think you can consider it with that consideration.
Go ahead, Debbie.
I do have a question. When we did talk about that, and one of the concerns was in the staff report, you had talked about when there was like affidavits that some counties were requiring and things of that nature, but there was really no way to monitor or staff that. So am I to understand that because of this form and the tax that they're collecting, they have to fill out, it'll circumvent that'll solve that problem?
Well, the affidavit is more associated with monitoring and impacts associated with a whole house rental in a non-hosted situation. And typically, the vacation rentals that end up being problems are the ones where the property owner is not there on site to control the activity. If the property owner's there on site and the people are partying in the house, they're like, hey, stop or you're out. So we don't have the same kind of enforcement action that you would if the property owner was many miles away.
Yeah, I thought this was just to circumvent like people saying it was hosted, but they didn't really live there. They were renting it out if we wanted to reduce but it seems like the form you have takes care of that they'll have to show how many days it was rented out and okay.
Right. And then they have to register for and pay TOT. So they can't both pay TOT and claim a homeowner's exemption on the house. So yeah, I'm not sure what we're looking for in an affidavit, but we'll get there.
Whatever.
So I was under the impression that ADUs built after July 1st, 2017 were giving a break on fees. And therefore, there was an ordinance passed that did not allow ADUs after that period of time because essentially it was double dipping. You're getting a break on fees to build the ADU to hopefully have long-term individuals live there. And then so that was not allowed. I believe that after SB 9 rules, where more ADUs could be built, that was kind of after that fact. And so do you know anything about that? Because that's what I recall.
Yeah, I think what you're getting at, Everett, is so the fact that if an ADU is built after 2017, they are subject to less impact development fees for their project. As a vacation rental, which is in our ordinance, either hosted or non-hosted, requires a conditional use permit, which is more than a staff level approval. So it kind of, in some ways, it balances out the fee requirements for, it's more it's more of a process to go through if you construct an ADU after 2017 to have a hosted vacation rental, because it is a deposit $3,000 use permit fee, as opposed to an administrative fee that's roughly about $500 and takes, less than a month to process. These use permits can take up to 4 to 6 months to process and have a lot more fees. The ADUs built before 2017, took longer. There was more fees involved. So there's kind of somewhat of a balance where it's a little bit more difficult for homeowners to do an ADU or propose a vacation rental for an ADU built after 2017.
Okay.
Does that help?
Yeah, I mean, I know that it was kind of required a permit from Planning Commission. I just thought it wasn't allowed at all, that because of those fees, because, for example, it would have been a difference of about $20,000 in fees versus $10,000, after the 2017. So was part of the thing was, hey, we're going to waive these fees so that it can be for long-term living, but you can't use it for vacation rental. And maybe I'm mistaken on that, but that was my understanding of it. I'm just trying to get clarification on it.
The state legislature absolutely said that when they started the whole series of ADU reforms and the reductions in fees. They absolutely at that point said that a local jurisdiction can prohibit them from being used as vacation rentals. But it doesn't blanket prohibit the use of, the only ADU use that it blanket prohibits as vacation rentals is the junior accessory dwelling units.
Okay.
Any other staff questions? If the applicant is available and wants to make a statement, now is your opportunity. All right, do you have anything you'd like to say, or just be available for questions? So we can record you. It's okay. It's all right. Is it green?
All right, this should work now.
Yeah.
Okay. I understand that it's kind of a complicated situation, and I've been following the past meetings and understand that there are kind of different opinions. One of the reasons why we submitted this permit is that, I've been laid off, to be completely honest, and we saw the time that my in-laws, sorry. Okay. Oh, I don't have to keep my finger on that. Okay. That was the, and given the job market, we figured that the time where my in-laws are not there, which are helping with the kids, which is great, and give us a break on, childcare and whatnot, would have helped us kind of bridge the gap between, not having a job and having a job. That said, we believe that we are here, our kids go to Parkside, we are well inserted in our community, and our neighbors know us. We have dinner together, we go by first name, and we are friends. So we have no intention to, turn something in party town or anything that will create a disruption in a neighborhood. And we have kids too, young kids, so we don't want trouble in that sense with strangers, bringing noise or inappropriate behaviors. I'm also here to answer any question that y'all might have about our situation.
Great, thank you. Any commissioners have questions at the moment? Go ahead, Evan.
What source are you planning to use to get renters?
Oh, right now, my wife is more into those weeds, but I think that she's looking at Airbnb. And then there are, I heard, other people that have family coming over seasonally, and they're always looking for places to stay. That happens, for our friends that have folks in New York, and they come here and that's one way that, knowing that we're here, then we will pay the necessary fees to the city. But these are the two ways that we see right now.
Okay, thank you.
Yeah, absolutely.
All right, if we have any other questions, we'll let you know.
All right.
Thank you. Anyone want to start a discussion or make a motion or comments or?
Your public comment.
Oh, I'm sorry,
first.
public comments. Sorry. So I see no one in the room, so we'll go to Zoom for public comments. And Linda, if you want to unmute yourself and make your comment, you have 2 minutes.
Okay, so anyway, the fellow there, he sounds like a very nice person, and as far as I'm concerned, makes a good case for him to get whatever he wants. But overall, in the larger picture, you should be aware that it was right there on Bodega Ave that we had a 4-foot by 4-foot sinkhole. In the larger picture, you lack the infrastructure for continued building. We lack the infrastructure for even as is. The roads, you know, are rated at 40% out of 100, 40 out of 100. Anyway, they're poor, in poor condition. We don't have the water and the sewage facilities. They're all old and need repair and maintenance and replacement and stuff. Our wireless water meter thing, for which we paid $2.2 million, still paying for it for the next 12 years, is failing. This is poor policy planning, you know, and I put it right on the lap of our mayor, who still refuses to acknowledge the $5.6 million loan that was part of this 2 years ago. So anyway, the overall thing, we need open spaces. We need to repair the infrastructure, and we are barreling with your complicity, I'm sorry to say, toward bankruptcy and congestion. We don't have traffic. We need to start looking at bypasses. Bypass, you know, the
30
intersection
seconds.
of 12 and 116. Haven't heard anything about that, but we cannot continue to go on the path that you all are, you know, part of in business. Thank you.
Thank you for your comment, Linda. And then we have another Zoom commenter. If you want to unmute yourself, please make your comment.
Do you mean me?
Yes.
Hi, sorry, I was cut off, folks. This is Michelle Kelly. So my question was, and forgive me, I didn't see this on the application, is what percentage of time would the ADU be occupied by relatives? And the relatives, I understood, I got cut off, so apologies. The relatives are currently in this ADU. I listened to your last meeting, I'm sorry I couldn't be there, and you did have some policy questions about ADUs. So one of my thoughts is the permits are typically 3 years. Given this particular situation, would you consider one shorter than 3 years until you guys rattle out the policy? Thank you.
Thank you for your comment. And yeah, the applicant and have stated that approximately 6 months to the family members live in the unit. And then regarding permit time, these permits are for these hosted short-term rentals are for a year. So they have to come back in a year to kind of renew the permit. But that's at staff, right? That's not at a planning commission level.
Correct.
So staff will review their permits after a year. So this is a year-to-year permit. Okay, any other public comment? Seeing no hands on Zoom and no one in the room, I will close public comment and now bring it back to the commission for discussion. Any comments or start of discussion?
Most of you know how I feel about using other residences for guests rather than for people who need that housing. But since we don't have laws in place to stop that, I certainly support the laws that we have and will approve this use. I think it's okay. I don't mind the numbers that we have now. I'm more concerned about in the future. If this, is happening 5 or 6 times a year, I think we need to either change the process and let the city do it or stop it one way or the other. Because it does take a lot of time to go through these each time.
Go ahead, Debbie.
I actually am not for ADUs being used for rentals because I feel like it's taking it out of the housing market. And so I think we need to look at that. However, I do believe we should look at these one-off situations. And since there's family there for 6 months out of the year, I think it would be very hard to find somebody long-term to rent it for 6 months out of the year. So to me, this is an exclusion to what I would normally say. So my concern would be, and it's not about this particular thing, but these one-offs are going to come, and I think they make sense. But how do we really, track this? I know someone who has a house in Tahoe, and they only do friends and family because they don't pay any taxes for it because it's all kind of under the table. And so that would be my only concern. And again, it's not about this, it's just about general. I think these one-offs make sense. We need to be able to look at them. I don't think we're taking something out of the housing market because 6 months would be difficult. But my thing is how can we track this and make sure that it's being utilized properly and that we are getting our tax? That's all.
Well, I generally agree as far as, not taking housing stock out. But I find it difficult to make these approvals, whether, okay, someone is going to be staying there 6 months out of the year. Somebody else might be there 9 months. It might be there 3 months, and then to have to police these or to, kind of come up with some formula, are they there that period of time? Who's going to determine that? So I think that if it's approved, it should be approved as a vacation rental unit. They told us the intent, but for us to now go back and say, okay, well, you were there, you were there 5 months, you had family there, not the time that you mentioned. It just gets a little dicey. And then now you've got some people that can be there longer, some people less. So I think that, we should hear what their situation is, but really we either approve the permit and allow them to do the vacation rental, understanding that their situation is with their parents and so forth, or we don't. But to say we're going to approve it for X number of days and you got to keep track of it, it just makes it too difficult to do that.
Seth, do you have anything to say? Or? No. Anyone else? Yeah, I'm generally, I think these one-offs, again, like I agree. I don't feel like this is taking a unit off the rental market, long-term rental market, because we don't approve this. It's not going on the long-term rental market anyway. And I'm inclined to, allow people to use their properties. If they can make some money off of it, I think that's acceptable. And I agree with Ever. I think and even though there is an annual, I think I like the fact that this is an annual permit and does have to come back to staff, so we see how it is being used and not being abused. So I think that's a good thing. So I'm comfortable with approving, something like this again, like we've done in the past, similar types of things. And yeah, that's my opinion. So anyone else? Or if we have a motion,
I mean, I can
entertain
just
that
say
as well.
I won't pass it if we don't put in the time limit, because then I think we're opening ourselves to everybody coming and saying, I have family members coming, and we're like, okay, well, it's all or nothing, so go for it. And we will be taking houses off of the market. And, in the statistics, and then I went down that wormhole of research, when houses are not allowed to be used for vacation rental, they do put them on the market, the ADUs. They want money. So if they can't, they get more money and more flexibility. But this case, I think, is a one-off. I'm just saying, but you guys can all vote for it unless we made some precedents here about, hey, he's saying his family member is going to be there for 6 months. The other 6 months, it can be rented out. I just feel like we're opening ourselves up to take things off the market. But that's just my opinion.
So you're saying you want to put a 6-month condition on this?
That's what you're requesting, 6 months of renting it out as a vacation rental by owner, right?
Yeah, please.
Oh, that was my understanding. Your family is there for 6 months and you want to rent it out the other 6 months.
That's correct.
Okay, thank you. Yeah.
So you want
I mean, that's just
you would,
me. If every,
no,
yeah.
no, so I'm just saying that you would like, so you would like
Are you
180.
making a motion?
So, but I'm
I
just
mean-
saying that you would like a 180-day rental limit.
Right. And then my question would be for Joan then also, how do we, just because if we're going to set a precedence, let's do it clean. Like, how do we know if they are I mean, I guess there's no way we can really monitor if they're doing anything under the table, correct?
Through the chair. I would remind you, we now know that these are 1-year permits, and so it has to come back, and this section of the vacation rental code requires that they document compliance with all the requirements, including each date on which vacation rental was rented. And so if he's in compliance with what he's proposing to do, when this comes back in a year, then at the staff level, we would say, yeah, okay, go. If not, and he's renting it full time, we have a different ordinance in place by then, right? Between now and a year from now, you've requested changes be made to the ordinance. So hopefully we would have a different ordinance in place by then, and the 1-year permit would no longer be valid, and they would not be able to do a year-round rental of an ADU after that 1 year is told.
I have a question so if they come back next year for their permit renewal, say we don't adopt a different ordinance, or we don't change anything from our current ordinance, if they come back next year and it shows that they've rented that for 190 days, then we could deny it and say, we're not giving you a renewal of your permit because you said you only wanted 6 months and you've now rented it for 190 days.
If you put that condition on and you limit it to 180 days and they come back having rented it for 190, then yeah, I think rather than deny it, we would bring it back to you.
But I guess, do we need to set the 180 days, or because the applicant has stated in their application that they only wanted it for 180 days? Like, I guess, do we need to put the condition on, or is that kind of already inherent in the application?
I think you can, but I think it's also completely up to you. This is only a 1-year permit. If they're not doing what they're representing, then they don't continue the permit after the end of the year.
Excuse me,
Go ahead.
I'm not opposed to some restrictions and so forth, but I think to make these and come up with them on the fly, we are going to be looking at these ordinances, and we should come up with specific, if this is the case, then we do this, and this is how we're going to monitor it. And here's but to say, okay, let's figure out a policy now, today, for this particular client, I think makes it difficult, because we haven't really thought it through that much, and we haven't really, public comment should be allowed when we're making these changes. So again, I state that we should approve. I'm for approving the permit as a vacation rental period. Now, once you start putting stipulations, there's ways around it as well. So you're putting people kind of in a difficult situation that, okay, well, gee, I'm kind of limited, so I'll tell you what, I'm just going to rent it to you, not do it, through Airbnb where it's all recorded. We're just going to, to keep my days underneath. And I mean, there's just, there's a lot to it. So I'm not opposed to that, but I just don't think that tonight is the time to do that. And I think we should either approve or deny this request. And whether he says that, his intent is for 6 months, I don't think that should be part of the stipulation, because there's a lot to it. And if he comes back and talks to the city and they turn out to have rented it much longer than that, well, things change, and that's his priority, prerogative. But then we can also decide whether we want to renew it.
Do you want to make a motion?
I'd like to make a motion for approval of this property for a vacation rental permit.
And can we add the condition that staff mentioned at the beginning about the, having to come, the annual renewal? That was not part of the conditions, but can we add that as part of the conditions?
Well, also, was that already on there, or?
It was not in the condition. It was not in this. It was not in the conditions.
It's not in the conditions. It's part of the vacation rental ordinance.
It's
So we're
code.
asking to add.
Oh, so
add
it's
as a
already
condition.
part of the ordinance.
Part of
Yes.
the ordinance.
Okay.
Yes,
It's
we're
not
asking to
If
add
it's
it.
part of the ordinance, then yes. I don't want to add anything new that is not part of
Yeah.
the ordinance.
Second.
Okay, we have a motion and a second. Is there any? We have any further discussions? We need to discuss things in public over here.
You can do the protest vote if you want.
Okay, we have any further discussion on the motion? Okay, then we'll-
I guess I still don't understand if in the motion it doesn't say that he can only rent it out for 6 months because the applicant has only asked for those 6 months. Is that part of it now, or is it not part of it? His parents could not come this year and he could rent it out for the whole year?
The motion is to approve the application that we received as a vacation rental. The application says 6 months.
Okay,
So that's what we're
Okay,
approving.
great.
That's what was applied for, and that's what we're approving.
Okay, I understand.
Okay. I just want to point out that when
That's
there's a
not,
motion.
that's not what my motion was.
No,
That's what I'm saying.
Yeah, it was not. It was just to approve the application for permit.
So you're
for
changing the
vacation.
application in your motion?
I'm approving the permit. His intent is 9 months, but I'm giving him a permit to have a vacation rental, as is currently the policy.
Okay, that's the motion on the table, that it's changed from the application. So it would be a wide open rental of a ADU, so that's the motion on the table. So let's take a vote on the motion. I do want to just point out that a minute ago, we had a sidebar discussion while there was an open motion on the table, and we can't do that. We have to have only public discussions with an open motion on the table. Okay, thank you. So are you seconding, Commissioner Hanley, are you seconding that motion?
I understood Everett's position and I was seconding that.
Perfect.
Okay, so to be clear, we are allowing this to be rented for 360 days a year.
I think Everett's point is a good one. Let's get this figured out on our end before we start ad hoc adding conditions to every ADU that comes in here. We've got a year to figure it out.
But if the application is for 6 months, then we're not really making anything up here. We're just approving what he's asking for.
I'd like to point out that we often do this for the hours of operation. People want to have their business and they specify the hours they think will work. And rather than have them come back 6 months later and want to start an hour earlier in the evening or end an hour later, we don't have to go through the process. He's starting a new business. And so I can see the point of not doing that, just making it
Not
simple.
limiting it. Okay.
Yeah, just
Okay.
making
I
them
mean,
simple
Kathy,
and
I
then.
totally agree with you. We do that, but I
Let's-
feel, well, it doesn't matter. I mean, this is what the applicant is asking for, and so, anyway, okay. It's fine.
All right. Are we all clear now? Any further comment? Okay, now we can have a vote, please.
Commissioner Onger,
Yes,
Commissioner Burns,
I'll abstain.
Commissioner Fernandez,
Aye.
Vice Chair Henley,
Aye.
and Chair Fritz.
Aye.
So that motion passes with 4 ayes and 1 abstention. There is a 7-day appeal period. Should anybody want to appeal this, this does need to come to the planning department by 5 p.m. on October 15th. After that appeal period ends, if there's no appeals, then the permit is approved and you can go ahead and move forward with that along with the business license application.
Great, thank you. Okay, our next agenda item 7A is our training video. So we pull that up, please. Yeah.
How does zoning work? The zoning processes are among the most powerful tools available to communities to control how land use is used and regulated. Thorough knowledge of these tools is important to use and administer them legally and in the best interest of your community. This course introduces you to 9 common zoning processes. Zoning processes include creating the zoning ordinance, adopting them, and enforcing them. Other processes include amending the zoning ordinance, reviewing development proposals, and functions related to the Zoning Board of Appeals, which include appeals, interpretation, variances, and rezonings. If you are a zoning administrator, other processes might include pre-application with applicants and processing administrative requests, such as for fences or dwelling units. This course helps you gain insight into how the legislative, quasi-judicial, and administrative functions work together and help you perform your functions as a planning and zoning official. This diagram outlines the various roles and processes. The legislative body is the locally elected body responsible for adopting laws and regulations, like the zoning ordinance. With legislative acts, there is a presumption of validity by the courts because legislative bodies are elected by the people and can be voted out by the people. The exercise of judgment by a zoning authority operating under the rules established by the legislative body is generally not overturned unless it is shown to be arbitrary, capricious, and unreasonable. Under quasi-judicial, the Zoning Board of Appeals, or Board of Zoning Appeals, is the body responsible for hearing an appeal. This is similar to an appeals court, where a specific request or process is evaluated for compliance with a particular process or set of standards found in the ordinance. A quasi-judicial process does not determine if the administrative official or body made the correct decision. Rather, it determines if the decision was made correctly. There is an important distinction there, and we will go more into detail later on this track. An administrative process can apply to a zoning administrator, like the name suggests, and also to the Planning Commission. Administrative means a process to review a specific request that is authorized by an ordinance or other regulation. Administrative decisions are more prone to intensive judicial review than legislative decisions because administrative officials are appointed officials, in contrast to elected officials in a legislative body. Planning commissions often recommend policy, such as the language of the zoning ordinance, but adopting the final decision to adopt policy is a legislative decision. Administrative bodies or officials most often apply the law to a particular set of facts to make a decision, such as a site plan review or a routine zoning permit for a dwelling. Administrative decisions can also be more nuanced and involve the use of discretion or reference to the comprehensive plan as a basis for decision, such as for a special land use or a planned unit development. However, depending on your state's enabling legislation and the process that's adopted within your community, these processes could vary. Before we get too far along, here's a word to the wise. Zoning is considered a police power. We've discussed previously how police powers involve public health, safety, and welfare. As such, zoning falls under states' enabling legislation, another layer because it deals with the regulation of private property. Think of zoning as a legislative modification to the police power. Zoning is one of a number of laws, such as building and health codes, that are designed to protect public health, safety, and general welfare. Remember that zoning is a legal document, and it must fulfill the requirements of the state's enabling land use legislation. It should also be based on a policy guide, often referred to as the comprehensive plan. As such, the zoning ordinance should be a means of carrying out the policy within the comprehensive plan. Therefore, know your limitations. The creation of a zoning ordinance is a complex undertaking. It requires a wide range of knowledge, including planning and zoning practices and legal principles, the ability to write technical knowledge clearly and concisely, and organizational skills to make sure that the ordinance is properly formatted and does not contradict itself. Here's several other points to ponder. Keep the language of the ordinance as simple as possible. The goal of being user-friendly should apply as much to the public as it does to the Planning Commission or zoning administrator. Conversely, the language of the ordinance needs to be precise and detailed as to avoid loopholes or room for misinterpretation. Also, zoning is not a substitute for the comprehensive plan. The comprehensive plan is policy, and the zoning ordinance is regulation or law. Zoning approvals are always attached to the land. They may not be attached to an individual applicant. And standards are the basis for all decisions. The standards should be clearly articulated within the zoning ordinance, and if all standards are met, applications must be approved. Here's a knowledge question. What should you do if you make a land use decision, such as a rezoning, that is not consistent with the comprehensive plan? The answer is the Planning Commission should determine whether the application should be denied based on the comprehensive plan. Obviously, other factors must be taken into account. If the Planning Commission does approve the application, they should consider updating the comprehensive plan to meet the new and changed conditions within the community. Whether the ordinance is being written for the first time or being amended, the process is in essence the same: adoption, enforcement, and the occasional appeal. A very simplified process is, ideally, a comprehensive plan is developed. A zoning ordinance is based on the policy established within that comprehensive plan, is reviewed and deliberated by the Planning Commission, and then ultimately adopted by the legislative body. Over time, amendments would occur to the zoning ordinance. And then finally, after a number of years, the comprehensive plan is updated, which would require also an update to the zoning ordinance. Finally, changes are made to the comprehensive plan, which require an amended or updated zoning ordinance. Keep this process in mind as we continue through this course. Let's take a look at a diagram on how the zoning ordinance process works. As mentioned, local government officials create, adopt, and enforce. There may be times when an interpretation or appeal reveals the need to change or update the ordinance, such as a zoning or rezoning amendment. The zoning processes are governed by the respective state enabling acts. All zoning processes must conform to your state's zoning enabling acts. If zoning ordinances or amendments were not adopted or made consistent with the state's enabling act guidelines, it could make that ordinance or decision invalid. Let's review a few common zoning process scenarios. Scenario 1 illustrates the core sequence to the zoning processes. Start with a blank sheet of paper, create a new ordinance, get it adopted, and enforce it. It is important to recognize the relationship between these three processes. They build on each other to make a complete zoning story. Scenario 2 is if you've already adopted a zoning ordinance. If your community already has a zoning ordinance, you are likely to encounter this scenario. Assume for a moment that the ordinance needs to be updated for any one of several reasons, such as changes in law, community needs have changed, comprehensive plan has been updated, etc. Scenario 2 assumes there is an ordinance in place. Notice that an amended ordinance creates policy that still needs to be adopted by the legislative body and enforced. Scenario 3 involves unique situations that occur in enforcing and implementing the zoning ordinance. As the ordinance is implemented, unanticipated circumstances or unique situations invariably occur that lead to appeals, variances, or interpretations by the Zoning Board of Appeals. As the ordinance is implemented, unanticipated circumstances or unique situations invariably occur that leads to appeals, variances, or interpretations by the Zoning Board of Appeals. Or if sections of the ordinance cannot be fairly applied because they are difficult to interpret, it may be time to consider an amendment to clarify the language within the zoning ordinance. One example is if the Zoning Board of Appeals is getting frequent requests from one zoning district or one area within the community, let's say a lakefront property area, that is often requiring and asking for similar dimensional variance requests, it may be time to update the zoning ordinance rather than seeing additional appeals to the Zoning Board of Appeals. However, for sections of the ordinance that are working well, it is important to enforce them clearly and effectively and consistently throughout the community to maintain the integrity of the overall zoning ordinance. The zoning ordinance is one of the most effective tools that a community has to implement its comprehensive plan. While the state's enabling legislation dictates what needs to be in the zoning ordinance, there is often much discretion at the local level to what can be put into the local zoning ordinance. This process describes how the zoning ordinance should be created. However, as mentioned in previous courses, information in the zoning ordinance should be based on what has been adopted within the comprehensive plan. There are a few key tools and processes that should be followed. At the top of the list should be experts or those that are knowledgeable on zoning practice to be able to help shape, develop, and guide the zoning ordinance before adoption. Also, important knowledge about state and federal court cases is a key component, as we've previously discussed, that should be embedded, incorporated within the zoning ordinance in terms of regulations that are embraced and adopted. And finally, drawing from the experience of other communities, both good and bad, in terms of what works in terms of best practices in your area. Let's review the role of the Planning Commission in this process. The main responsibility for initially drafting the zoning ordinance usually falls to the Planning Commission. In most states, the Planning Commission is required to review all new zoning ordinances and amendments and make recommendations to the elected body. As discussed, the zoning ordinance is the community's primary means to implement the comprehensive plan. Zoning has a major impact on the value and use of land. It also establishes how park space, open space, and other important features such as commercial, industrial, and residential areas look and feel. Therefore, the Planning Commission's role in this process is very important. In addition, the Planning Commission in most states is involved in reviewing and approving subdivisions, site plans, and condominium and other land use requests. It's time for a knowledge question. Does the Planning Commission approve and adopt the zoning ordinance? The answer is no. The Planning Commission is only involved with review, but approval and adoption must come from the legislative body. However, in most states, the Planning Commission reviews the ordinance and its amendments, takes public comment, and makes recommendations to the elected body. In order to create a zoning ordinance, you need a process, and you need to know the content that that process will create. You can break down the process into 4 primary tasks. Preparation. Plan what needs to be done. Who are the professionals that will help? What is the budget? And what is the project timeline? Organization. Get organized by identifying the elements of the ordinance that need to be created. Preparation of content. Get to writing. Create the content based on the community's needs reflected in the comprehensive plan. And review and preparation for adoption. Review the draft ordinance, seek public input on the draft, and get ready for the next process, adoption. Controls, laws, and judicial opinions that control how the zoning ordinance is created. This diagram illustrates creating an ordinance. Output, a zoning ordinance ready for adoption. Mechanisms, zoning professionals, public input. Input, long-range planning goals provided in the comprehensive plan. Adopting an ordinance. Once an ordinance is written, it needs to be adopted or accepted by the community. The adoption process combines the elements of public participation and the legal requirements to put the ordinance into effect. Inadequate public participation can harm the ordinance, even if properly adopted. Failure to follow the legal process can invalidate the ordinance, even if the ordinance is widely accepted. The most important part of the process is to follow your state's Zoning Enabling Act. If the process established by the Act is not followed, then someone may challenge the ordinance and it may be declared invalid. The primary goals of adopting a zoning ordinance are to ensure that it's legally defensible and aid communities in achieving its development goals. While even the best ordinance is no guarantee against lawsuits, a well-crafted zoning ordinance that is consistent with the comprehensive plan is the best defense against lawsuits and helps ensure the sustainability and health of the community. Now it's time to adopt the zoning ordinance based on the legal process. How you execute the following tasks depends on your state's zoning enabling legislation. However, the following elements are nearly consistent within all states in terms of the basic process. legal notice, planning commission review in a public hearing, elected body review and approval, or if the elected body rejects the ordinance, sending it back to the planning commission for further consideration and amendments back to the elected body. Upon final approval by the elected body, notice of adoption is published. Welcome to Chapter 6, Amending an Ordinance. Over time, circumstances change and the ordinance will need to be amended. For example, changing land uses or new land uses appear. A recent example might be renewable energy, where the presence of wind towers or solar require new definitions and new uses added to the zoning ordinance. Also, because of changes in land use, the zoning ordinance will need to be updated to reflect those new definitions and new uses. This process, called rezoning, also includes the zoning map along with the text. So a rezoning includes either the map or the text or both. Requests for amendments can come from citizens, developers, the elected body, or the planning commission. It is important to carefully review amendments and be prepared for any unintended consequences. That's why the amendment process must be approached very carefully. For example, a community may wish to preserve or promote a single-family home ownership in a historic neighborhood. Over time, these neighborhoods may have been divided into multiple family residences because of large homes. These larger homes may provide affordable housing for families and residents within the community. So rezoning from single family to multiple family may meet one of the goals of the master plan. However, it may have the unintended consequences of displacing low to moderate income individuals that have fewer housing choices within the community. In this case, there might be an alternative to the rezoning by offering other financial incentives for historic preservation rehab. This would preserve the ability for the area to continue to have multiple family housing while also encouraging historic preservation rehab. Keep in mind that in some states, conditions may be placed on a rezoning, even if those conditions are not expressly identified within the zoning ordinance. This is going to be based on your state's statute and enabling legislation, or other legislation that allows for contract zoning or conditional rezoning, however it may be named within that legislative act. The process for text amendments and map rezoning is basically the same. However, the reasons to amend text are different from reasons to amend the map. For example, you might amend the text if there is new legislation or a new court case, or you may update the map if you need to reclassify a zoning area within the community. A quick tip: amendments need to comply with the community's comprehensive plan. Non-compliant amendments are often overturned by the courts for that very reason. Since the comprehensive plan is a statement of the community's goals and the zoning ordinance is a means to implement those goals, amendments should be based on the policy established within the plan. If circumstances have changed and a non-compliant amendment is necessary, it may be time to revisit the comprehensive plan to address those changed circumstances. Some land uses are appropriate in certain districts, but might have certain characteristics that might not make them appropriate in every location. For instance, a restaurant with a drive-through component may be appropriate in a commercial district, but may present some additional challenges in a commercial neighborhood district. This is an instance where in the neighborhood commercial district, it may be more appropriate to list the use as a special land use rather than a permitted use to address those unique circumstances within the neighborhood. Placing the restaurant as a special use within the district will allow the Planning Commission to review the site plan, consider the conditions that are appropriate for that use, and address any unintended consequences of the use within the neighborhood. This diagram illustrates special land uses. Mechanisms: zoning professionals' public input. Input: uses that require special land use review, applications for special land use. Controls: laws, judicial opinions, and zoning ordinance procedures that govern how special land uses are approved. Output: final review, approval, or rejection of a special land use. The zoning ordinance lists special land uses that can be considered for each zoning district. The process for evaluating and approving special uses varies from community to community. Depending on the community, a zoning ordinance may allow a special use to be reviewed, and/or approved by the zoning administrator, the planning commission, or the elected body, or any combination of two of them or even all three, where one body or official provides a recommendation on the special use request to the approving body or official. There are some states through state enabling legislation that provide standards for all special land uses or specific special land uses that must be applied. For instance, under Michigan law, special land uses must be compatible with all surrounding land uses. However, communities can put specific standards in place, let's say for a drive-through establishment, to have a number of stacking spaces for cars through the drive-through. Here's a quick tip. The community may create specific requirements on what must be included on the site plan, but common elements include the following: drawing size and scale with north arrow, location map, bearings and distances of property lines, dimensions of all existing and proposed buildings, setback distances for all existing and proposed buildings, density of residential developments in dwellings per acre, location and description of all uses within and adjacent to the district, location and dimensions of all parking spaces and aisles. While many zoning processes are limited to what's allowed within the state's zoning enabling legislation, most states allow for a powerful tool that communities can use to address creative development. This is known as planned unit development. The planned unit development, or PUD, is a creative way where communities can work with the developers to relax certain zoning ordinance requirements to have a high-quality development. Planned unit development provides a unique opportunity to address certain unique aspects of the site, such as key natural features that need to be preserved or providing a mixes of uses on one site, otherwise not allowed within the zoning ordinance. For example, a traditional site development through a subdivision may not allow for lots that address the unique natural features of a site. A planned unit development is an opportunity to relax certain provisions to preserve those natural features while still maintaining perhaps the same density on the site. Generally, a community is allowed to address through its zoning ordinance how a planned unit development will be reviewed and approved. PUDs can be made a special use in certain districts or their own district within the zoning ordinance. In these communities, the project is rezoned to PUD and the conditions and site plan are part of that new district. PUD approvals are also based on standards of review. A site plan is approved and is made a part of the PUD. Keep in mind that a PUD allows for development that otherwise might not be allowed under the standards of the local zoning ordinance. Typically, a PUD project must demonstrate that significant benefits would be obtained by using the planned unit development option. In Michigan, as in other states, a planned unit development is often used in large, complex projects where there's a need for a coordinated development and often a mix of uses. Many PUD ordinances require the PUD to meet one or more of the following requirements: preservation of significant natural assets, such as woodlands, rolling topography, significant views, natural drainage ways, water bodies, floodplains, wetlands, or natural corridors, provision of recreational facilities and open spaces, and a complementary and integrated mixture of uses, residential densities, and housing types. The PUD regulations must specify the standards and conditions for approval and adoption of the planned unit development. Here's a knowledge question. So how does the community benefit from using a PUD? Although the planned unit development means the community is relaxing certain zoning provisions, there are also benefits to be gained by a planned unit development. For instance, in exchange for an increase in density, the developer may preserve a larger area of open space or natural features. Or in exchange for a reduction in the number of parking spaces, a commercial developer may include additional architectural features or landscaping within the site. Appeals, variances, and interpretation. The Zoning Board of Appeals has a very difficult job. But overall, maintaining the integrity of the zoning ordinance and the goals of the community are key to the role of the Zoning Board of Appeals. The ZBA hears appeals, grants variances to the ordinance, and offers interpretation when requested. But since no zoning ordinance is perfect, residents need a mechanism by which to appeal decisions, request variances, and ask for interpretation where language may not be clear within the zoning ordinance. Remember that an appeal occurs when someone alleges that an administrative body or official has made an error in a decision regarding what the ordinance permits or in the enforcement of the ordinance. In zoning, just like in the courts, no one person or body has complete authority. There is a system in place to appeal a decision, just like a person can appeal a traffic ticket or a court decision. The most common type of variance is an area or dimensional variance. This is sometimes called a non-use variance. Practical difficulty is the legal standard applied by many states. Practical difficulty is characterized by unique features that were not created by the owner, and is not something that is generally present within the zoning district. Also, the circumstances of the practical difficulty cannot arise by the actions of the property owner. For example, a property owner that builds a large deck and is now asking for a variance request for a new garage, if the setback requirement cannot be met for the new garage because of the deck being built, this is an example where the problem was self-created. Another example might be an addition that requires more than a 10-foot setback, and the addition can actually be less and meet the zoning ordinance requirement. These are conditions where the condition was self-created. These are examples of where the practical difficulty is self-created. Note that not all states apply these types of standards. For example, in New York, the 5 criteria for evaluating an area variance are established by state statute and generally require a ZBA to balance the benefit to the property owner in granting the variance against the potential harm to the community if the area variance is granted. A use variance is requested when one wishes to deviate from the use restrictions of the zoning ordinance, which can be granted if an unnecessary hardship exists. Generally, unnecessary hardship exists when there is no reasonable use of the property from the uses that are allowed within the zoning ordinance. Not all zoning ordinances are completely clear. Even though the zoning administrator might regularly interpret language within the zoning ordinance, there might be instances where certain sections contradict one another. This may require an interpretation by the Zoning Board of Appeals to help clarify. An interpretation of the ZBA is final and should be used in moving forward with that same circumstance. A legal opinion is strongly recommended for interpretations of the zoning ordinance. State zoning enabling legislation determines when a person aggravated by a decision may appeal that decision. For instance, the zoning administrator or the person responsible for administering the ordinance may make a determination that a home occupation meets the ordinance guidelines. However, an adjacent neighbor may come to a different conclusion and challenge the decision before the Zoning Board of Appeals. The ZBA must determine whether the zoning administrator made the decision based on the requirements and standards within the zoning ordinance. The role of the ZBA is not to determine whether the zoning administrator made the correct decision. It's important to remember that the decision has already been made. Did they use and follow the standards and procedures within the zoning ordinance? Did they interpret a meaning of a standard and apply it correctly? Sometimes there are unique aspects to a property that make it difficult or impossible to meet the standards of the zoning ordinance. For instance, a property may have a stream running through the middle of the property that may make it difficult to place a house given the required setback requirements. In such a case, the owner can request a variance. The stream running through the property creates the practical difficulty that makes it impossible for the use of the property. The stream is a unique physical feature of the property that the owner did not create. Practical difficulty is just one of several standards that the Zoning Board of Appeals must consider for a variance. An interpretation is requested when language within the ordinance is vague or unclear as it applies to a particular piece of property. For instance, a house may be located on a steep slope adjacent to another house. If a fence is erected on the steep slope of the house, and the ordinance requires that a fence be no greater than 6 feet above grade, how should this be interpreted? The problem is which grade? The grade at the top of the hill or at the bottom? The ZBA would review the text of the ordinance and the situation to determine how the interpretation should be measured. Ideally, the zoning ordinance would be amended to address this situation that may occur on other properties in the future. Here's a knowledge question. Can the Zoning Board of Appeals overturn an action of the enforcement officer if it disagrees with the determination of the enforcement officer? The answer is not if the officer's determination was done in accordance with the ordinance standards. Only if the ZBA finds that the action of the officer was not in accordance with the ordinance standards may a different result occur. Zoning ordinance enforcement. Even the best ordinances are useless without vigorous but fair enforcement. Each community must decide on its own enforcement policy and provide the necessary means to carry out that policy. At the same time, the enforcement officer must use sound judgment and tact. Not everyone is cut out for the job of zoning enforcement officer. An effective enforcement program requires consistent enforcement following the ordinance and utilizing a process that emphasizes compliance, not fines. It is important to be consistent with zoning ordinance enforcement as there are consequences of poor or non-existent enforcement. For example, if the ordinance is not consistently enforced, some property owners will learn that there are no consequences to violating it. This will make it much more difficult to enforce later on, as future violators will point to earlier decisions in which violators were allowed to continue with certain practices. Why have a zoning ordinance if it cannot be enforced? Zoning ordinance enforcement is a process unto itself. Each process should have some essential steps. For example, discovery, identified by active enforcement or complaint. Notice, the process to notify property owners and for them to alleviate the situation before citation. Citation, the legal action. And follow-up. Was the situation corrected or is further enforcement necessary? This diagram illustrates enforcing the ordinance. Mechanisms. Enforcement officer, courts of law. Input. Zoning ordinance, enforcement philosophy. Controls. Laws, judicial opinions, zoning ordinance procedures, and community policies that govern how zoning ordinance is enforced. Output. A consistently and fairly enforced zoning ordinance. Managing the zoning processes. Creating, adopting, and amending the ordinance is not the end of the process. Administering your zoning ordinance is a daily procedure that includes working with the planning staff, developers, and the municipal attorney, if they exist, interacting with other planning commissioners on other boards and commissions, making decisions, and learning from your mistakes. You will need to keep up with court decisions and other zoning acts and changes that occur at the state level. Depending on your community's enforcement philosophy, you must also be able to work with both violators and complainants. Since land use is an ever-changing landscape, the challenges never stop. Along with creating the comprehensive plan, managing the zoning processes and making tough land use decisions may provide the greatest challenge to the planning commissioner. But the rewards of a well-planned and implemented zoning policy, a livable city for the future, is well worth the effort. Here are some quick tips. Zoning fees are set by the legislative body. Fees should not be included in the zoning ordinance because changing them would require an ordinance amendment. Zoning fees should be set to recoup the cost of services provided. Some zoning fees, such as for a variance or a special land use that requires a public hearing and a public notice, are substantially higher than routine permits in order to recover the costs of that service. But be aware, you can only charge for reasonable expenses, and some state courts and legislatures have limited the expenses that can be charged for zoning fees. Welcome to Chapter 12, Activity. You are the newly elected supervisor of Anytown, USA. Anytown has recently adopted a new comprehensive plan that has as its primary goal the preservation of the rural character of Anytown. Your current zoning regulations are old and allow property in the agricultural district to be divided into lots as small as 2 acres. On top of this, developers have started to inquire about purchasing farmland for home sites, and many residents fear that the goals of the new comprehensive plan will not be realized. Is this a good time to revise the Anytown zoning ordinance? Yes, the adoption of the comprehensive plan is also an excellent opportunity to amend and update the zoning ordinance. The zoning ordinance is the best means a community has to implement its comprehensive plan. What are some zoning processes that any town could use to implement the goals of its comprehensive plan? Any town has several options, including revise the ordinance to create an exclusive agriculture district that identifies on the map the area that the primary intention for agricultural purposes, and use planned unit development to encourage compact development on a portion of the parcel while preserving the farmland and open space on other areas. There is a lot of pressure to rezone portions of any town to permit higher density housing in the more rural areas outside of town that are adjacent to farmland. How can any town respond? Any town may deny the zoning amendments if it does not conform with the comprehensive plan. If the plan calls for increased residential development in areas of the city where there is water and sewer, and the proposed development is outside of that district, this may be a reason to deny the rezoning request. Any town may also want to work with the affected rural property owners to see if planned unit development process could be used to address the issue of increasing density, but also providing for the preservation of rural character and agricultural land. Now you should be able to identify 9 processes associated with zoning ordinances. Identify skills needed to execute the zoning ordinance processes, and identify when each process is performed in relationship to the others. This concludes Course 10 of the Planning Commissioner Training. For more information about Planning Commissioner Training and about becoming a Master Citizen Planner, visit the website below.
This was the last one, right? All right, we made it through in like 3 years. Yeah, a little bit.
No quiz?
Oh, you want to take the quiz?
No.
We might have to kick you off if you fail. I have a question. Isn't there for the general plan, isn't there like a certain number of times you're allowed to amend a general plan in a year?
Correct.
But a zoning ordinance doesn't have that limit. Can we amend it?
Yes, I don't believe there's a limit for zoning ordinance amendments, but general plan amendments, yes, there's typically, I think it ranges between 3 and 5 over that period of time.
And this is completely aside, but I noticed in one of their slides, they had a thing about inoperable vehicle ordinance. You may want to consider that based on our walk of that property, the Miller Oil property. You may want to consider amending our zoning code to include an inoperable vehicle ordinance. Just saying. All right. And with that, we have subcommittee updates.
Do you want to give an update on our last get together?
Well, Everett and I and John and Lynn Diedler of the DRB and members of the Friends of Ives Park met. And I think the meeting was called primarily because Ann Riley, who worked on the Ives Creek restoration process and is looking for grants, is aware of letters that Lisa Pierce has entered into the record in opposition to the creek. And it looks like their main concern is that A, it's going to take too long, and B, they are feeling that there won't be enough land for big events like Peacetown, because so many families with children and other people in food trucks use the space on the west side of the Creek Division area, and they enjoy the redwood trees, and all of those things would change with the new plan. She also was concerned that there's a lot of elevation change that isn't useful to people based on some of the diagrams she saw in the drafts, which are totally schematic. So there's a lot of information she and we don't really have yet. So I'm hoping that she will wait to look at that information as it comes due. Meanwhile, I'm concerned that public meeting that she thinks the new council, because won't want to continue working on this, but will want to keep the park the way it is because of finances. So that may occur in the future. It's good to know that. Otherwise, on the good side, they're interested in working with existing organizations that will maintain a bucket for the Friends of Ives Park. And they're looking at the things that we did over the last 4 or 6 years. I don't know how long we've been working on this. And they've created a spreadsheet. And in going through that, I noticed some things that I will recommend that they consider changing. One, Everett pointed out that we also, in our documents, had a list of things that we had accomplished by working with Dante and Public Works to achieve them with very little funds over time, and in working with Rotary to come up with funds for projects that they would get behind. So it's nice to see that we have done things. We'd like them to put that into their list if they could. We'll give them credit for it. There are also some things that they missed. Some things have been done, like the lowering of the gate near the children's playground and the repairing of that, removing the wooden fence at Jewel and Willow. And we've already talked to the Public Arts Committee, which is no longer a city committee, about doing a mural, and we got feedback from them, so they can benefit from that feedback before they approach them again. And I'll talk with her more on that. I've also totally measured and documented the spaces and their sizes and lengths so that she can use that information rather than repeating it. The other things is that we listed things on the back burner that we didn't think Dante should spend money or time on because of their location and the situation around them, and would focus instead on the things that we still had on the list. And she could take those off if she's going to be raising money for them. She should understand why they were there. And she also uses the term part of the Creek Restoration Master Plan. And since they're looking at spending money between now and maybe another lifetime when the restoration actually occurs, I feel they should go ahead and work on those things if they're going to raise money, because some of them will really draw the community in. Things like getting citizens interested in being friends of this area of the park, or friends of the children's playground, or friends of the perimeter fencing, or new friends of the Redwood Memorial Grove, things like that. So we should take those things off the hold list. And then there's the general category on hold due to the creek plan. And peppering the whole list with things like that, I think, is unnecessary and kind of skews it to the fact that we can expect them to make some really good changes in the park between now and the time we have a new creek, if and when that ever occurs. the realization is that it could take a long time or it may never happen. So I think they should go ahead, and I'm encouraging them to do that, knowing full well that they're trying to sabotage it, which is, I think, sad because there is money for creek restoration and not so much money for channelizing creeks and leaving them underground. And we're going to need some repairs there anyway at some point. So questions, comments,
Yeah,
anything
thanks.
else, Everett, that you want to add?
Yeah, so I think it was good for us to kind of get together, and thankful for Riley, because I think there's some misinformation, or people are, not really understanding things, that, gee, why do we need to wait? We want things done now, and not understanding that you can do things now, but they may have to be undone down the road. I think the one thing we all agreed on was the railroad forest past the postal station, that, that's where everything gets clogged. That's what causes flooding, and that there's work needs to be done there. And that was one thing that was, everybody was in agreement in, that just, adds to all of it. But, that's complicated because that's Fish and Game, that's Laguna Foundation, Sebastopol Open Space District. So, but, at least it was something we kind of came in common, and I think it was good for all of us to kind of meet and, really also appreciate the volunteer work that Riley's done, that some of the other people that she has there working with her have done. And I think we just need to recognize that, regardless of how this works out or whatever, we've got a real expert that also is an expert in applying for funds and funding. And, we need to foster that.
Did Anne have any idea of, grant availability or kind of timing of that, or has she given you any sense of that?
Yes, apparently she could have submitted the grants, just very bad with things like this, I think in September, but because of this, they held off. But there is another grant cycle and proposals that this would qualify for in January or February. And I said, you should go ahead and do it. But I don't know whether Don Schwartz is holding that back or whether there's other procedures. But I did I ask you that this isn't being held up because of this committee?
No, I don't believe so. So I think kind of the direction that I understood was just to kind of move forward with the grant funding component. I know Don had reached out to me as far as, and Riley, as far as, when the next cycle was, and knowing that this one kind of passed, but there were future ones coming up. And as part of that meeting, Anne had mentioned a couple other ballot measures that were coming up that would really open up even more possibilities for funding and stuff like that. So I think it's something that, we're looking forward to in the future. It's not anything that's going to get solved overnight. I mean, this project has been going on for years. The more I learn about it while I'm here. So I think just staying on top of what is available. And, one of the things that she did mention was a lot of the funds are geared towards the planning aspect of the project. So, if things do need to change or be modified or whatever, there's funds available to do that.
Thanks.
And then one more thing I thought was important is that as they work, that they communicate with us, or that we take turns being part of the process so that we can bring things back to planning. And certainly working with Dante, I mean, sometimes we were stymied by Dante. Maybe in the future, and a new director will have a different opinion, or maybe the situation of homelessness and vandalism will change slightly enough that that the situation will change, and we can always hope for that. Another good thing is that we notice the area between near the children's playground and the parking lot for the vets building is very barren, and it used to have plantings there, which they took down partly because of homelessness and danger, because they had outlived their life usefulness. but working on a project to establish a better looking fence there that is useful, and different types of landscaping there that will make it a nicer place to be, close to the children's park and make it more useful for that, are things that they were kind of excited about. Thinking about amenities like what the bridges might look like, and how I was suggesting the way the bridge looks on the Joe Rodota Trail as the bike path verges off to downtown to Morris Street. There's a cutoff and there's a bridge over the waterway there that has an interesting rustic but very sturdy style. Looking at something like that and fencing that worked with that for the park, or perhaps old-fashioned wrought iron, which I wasn't as fond of. But if they start looking at character like that, I think we can, it will be useful time spent.
I mean, I think this is great that there's someone that's sort of stepping up to organize the kind of, Friends of the Park and try to raise money for it. I think, us being the Parks Commission as well, I mean, whatever they're proposing, I think does need to come through us. Obviously, they shouldn't just be able to do whatever random thing they think is important in the park.
Although sometimes Public Works has just gone ahead and done things, but by
Yeah.
giving them direction
Yeah.
and priorities, they were doing those things, like painting the lamp posts.
Yeah. Yeah. So I think it's just important to keep us in the loop. And yeah, I agree. I think, we spent a lot of time with the creek restoration plan, and I think it's, would be a great thing for the park. The creek is so sad in the
Yeah.
park right now. And I mean, I appreciate the community gathering sort of aspects of the park. And I think the two can coexist, and I don't want to, completely abandon the idea of creek restoration for an event that happens 8 times or whatever, however many times we have Peacetown weekends or weeks in the summer. It's great and it's fun and people like it, but there's a lot of other days throughout the year that big events like that don't happen, and it'd be nice to have a more useful park on the rest of the year as well.
Mhm.
Any other thing on that? I'll just report Kathy and I did a walk last week to our little subcommittee for the kind of zoning reform discussion. So we had some conversation, and yeah, so we'll kind of continue kind of coming up with a plan for proposed updates and bring that back at some point. And then any news from the planning department?
Yeah, just a couple. So our next meeting will have 2 updates. One will be from the SCTA Active Transportation Plan. That will be the Milestone 3 update. I had sent out an email to planning commissioners as well as all of our other boards and commissions that the public draft is open for review. That does end at the end of November. As part of that draft, it will also be going to City Council as a draft in November. I believe the second meeting is what we have scheduled. And then for them to provide any kind of final edits before it comes back for adoption. It does need to be adopted by February of 2025. So we would be kind of looking at that January probably time frame to bring that back for adoption. The other update is the Sustainable Transportation Grant. We'll be coming to that our next meeting with an update for what they've done so far. They've been working on the existing conditions and the public outreach component of the project. And we'll also be looking at scheduling kind of one of the first stakeholder group public events in November. So we'll be reaching out and trying to nail down a location and time that works for everyone. That will be, one part of it. There'll be additional ones in the spring and then fall of next year. So that's kind of it about the ongoing grant stuff. Not much has changed since the last meeting for development projects. Woodmark has been finalized. They are taking in applications for those first 48 units. Canopy is under review for their site improvements and should be submitting their building permits soon. Same with Huntley Square. And the Kathy Austin project is scheduled for the November 5th meeting with the city council. So that's about it.
Any questions?
The Habitat project?
Yes, the Habitat, I believe, I spoke to Patty, I think it was last week or the week before. Those are just about ready to be issued to them, their building permit. So that should hopefully be under construction pretty soon. So
Great.
I know that site's been vacant for quite some time too.
Long time.
Yeah.
There's no other questions or comments. I will adjourn us until October 22nd. Thank you.
Recording stopped.